Hello, I'm Frances Deegan Horowitz, President of the City University Graduate Center. Welcome to Women, a series of programs for and about us. The American Civil Liberties Union has been an advocate for the protection of our freedoms and rights since 1920. Since September 11, 2001, those freedoms and rights have been questioned, discussed, and threatened from within and without the country. We'll discuss many of the issues that confront our democracy with New York Law School professor Nadine Strossen, who's been the president of the ACLU since 1991. Welcome.
I'm so happy to be here, Frances.
Good to have you here. You grew up in Minneapolis.
Yes, I did.
Did you go through college?
I moved east to go to college and law school at Harvard University, and then I decided to go back to the Midwest, where I thought it would be easier for a woman and a young lawyer at a time when relatively few lawyers were women to have an opportunity to be influential.
And how long did you stay in the Midwest?
3 years. I decided I would come to New York, which I had visited often as a child, to live here for a few years or until I got tired of it. That was 1978, and I quickly realized I would never get tired of New York.
How did you decide to go to law school and become a lawyer?
Well, in those days, it really was rare. I have to put that in perspective. Now, about 50% of all law students are women. But back when I was in college, there were only about 3% of all lawyers were women. And it honestly never penetrated my consciousness when I was growing up in Minnesota that I could be a lawyer. I so admire the women who were the very first in their fields. I will confess, I didn't have that imagination. I didn't see any women lawyers growing up, and I was a very active member of my high school debate team. One year we had a legal issue. I used to do my research at the University of Minnesota Law School, and I said to all of my debate partners, who were all males, you should go to law school. And it never occurred to me that that was an option for myself until I moved to Boston and finally met women lawyers who were very involved in the women's movement, the reproductive freedom movement, and they were such inspiring role models for me.
And so you decided to go to law school while you were still an undergraduate?
When I was an undergraduate. It was clear to me once I realized that the door, I knew I was an advocate. I knew I wanted to change the world when I realized that law school would open its doors to me, which, by the way, Harvard Law School did not open its doors to women until shockingly recently, not until the early 1960s.
And when you were in law school, were you just among a handful of women?
About 10% of our class in terms of students were women, and I had 0 faculty members who were women in Harvard Law School.
Was it daunting in that sense?
Well, you always felt as if you were part of a conspicuous minority, and it's certainly true when I was on the job market. All of the firms in Minneapolis and St. Paul, almost all of them had at least one woman, but it was usually only 1 or 2 that they had ever had in the entire history of the firm. So you definitely felt as if you were conspicuous. There was pressure to represent the gender well in terms of being an outstanding lawyer.
What area of law did you decide you wanted to be in?
I did what every intellectual dilettante does, Frances, and that is to become a litigator, because you don't have to specialize in a particular legal area or factual area. You get to do a little bit of everything. It's like continuing general education.
And how did you get to be a faculty member?
That was really a fluke. I had always considered myself an activist and am an activist rather than an intellectual. A friend of mine from law school who was teaching at NYU gave me a call. He said, I know that you've been doing a tremendous amount of pro bono work in private practice for the ACLU and human rights work, human rights organizations. We have an opening at NYU Law School to be a supervising attorney for the Civil Rights Clinic. You could do all of that work, earn a living, and train students to become human rights and civil liberties litigators. So I jumped at that opportunity, and during the first year on the faculty, I wrote 4 law review articles. I discovered, to my amazement, it seems naive,
that you were an intellectual.
Well, that you could be an activist and an intellectual, that you could write articles that could be helpful in influencing judges and legislators and other policymakers.
How did you get to the ACLU?
I have been an active member of the ACLU ever since I heard of the ACLU, and I honestly don't remember when that is. I suspect it was sometime in college or law school, but it was an organization that absolutely fit my passions and commitments and values from as far back as I can remember, and it became such a great joy to join with other like-minded people and exert our collective influence to affect policy.
You know, I think I mentioned to you before the program started that my husband was chair of the ACLU when we lived in Lawrence, Kansas, and I always recall his experience with the editor and publisher of the local newspaper, who was an extremely conservative man. Mm-hmm. But he said to my husband once, you know, if the ACLU did not exist, we would have to invent it.
I think that's wonderful.
And he really appreciated the role of the ACLU in our democracy.
I think that's true for many people, even those who disagree with many of our positions. They respect the fact that we are there to the best of our ability to neutrally enforce all fundamental freedoms for all people, no matter who they are, no matter what they believe, even if they are themselves anti-civil libertarians. And I think a lot of respect has been gained for the ACLU when folks see us standing up for people who are disagreeing with our positions. For example, when we defend free speech and freedom of association rights for anti-abortion protesters outside abortion clinics, even though we defend freedom of choice. Here in New York, the New York Civil Liberties Union has constantly come to the defense of the ancient order of Hibernians when they are staging their private St. Patrick's Day parade and want to keep out the Irish and lesbian gay organization. Even though we're on the forefront of lesbian and gay rights, we understand that that's their parade and they can keep out anybody they want to keep out, just the way the gay pride parade can keep out anybody it wants to keep out. I think it's also important to note that it's really not surprising that conservatives would support civil liberties. When you think about it, the core notion of classic conservatism is minimizing the power of government, particularly in our private lives. As that revered conservative Ronald Reagan used to say, let's keep the government off our backs. And that is, in essence, what civil libertarians make our core mission too.
The ACLU has you're the head of the national ACLU, but there's also a state structure. And so each state has its own ACLU with its own president?
It's a little bit more complicated than that. We have what are called affiliates that are state-based, and in fact, in some states we have more than one. Just if the state is large enough, take California, with so many different civil liberties issues and political climates throughout the state. We've got a northern, southern, and California affiliates, as well as one in San Diego. But basically, the point is that the organization operates not just in New York, where our national headquarters is, not just out of Washington, D.C., where our national legislative office is, but we are present at the grassroots level through state-based affiliates and chapters throughout the states, including many university chapters. Tip O'Neill famously said when he was Speaker of the House that all politics are local. It's certainly true that all civil liberties are local. No matter how many victories we might win in the United States Congress or the United States Supreme Court, they mean nothing if they are not respected, if the Supreme Court decisions or the civil rights laws that come out of Congress are not respected, not known, and not enforced by local police, by local school teachers, and by other local officials. So we absolutely depend on having a grassroots presence.
But the grassroots presence doesn't only take its lead and instructions from the national.
To the contrary, absolutely to the contrary. It's a mutual relationship. Cases that end up in the Supreme Court, issues that end up before Congress, often, in fact always, I think it's fair to say, start somewhere else. When Ruth Bader Ginsburg founded the Women's Rights Project at the ACLU, she said that one of the reasons why she chose the ACLU as the location for her law reform activity was precisely because of this affiliate structure and chapter structure where our local folks could identify appealing cases and clients that could then become the vehicle for a case that would work its way to the United States Supreme Court. and become a vehicle for law reform nationwide.
But the national can take a position without reference to an affiliate.
Absolutely. And what national would tend to do, Francis, would be if Congress is passing a statute that we think is unconstitutional. Right now we have 2 constitutional challenges pending to provisions of the USA Patriot Act that was passed in a rush after 9/11. That is handled by the National Office of the ACLU. Or we have national experts, for example, in our Lesbian and Gay Rights Project that would coordinate with affiliates around the country on particular issues such as all of the challenges now to state laws that prohibit same-sex marriages. So it's very much, it's a little bit like the United States government itself. I hate to sound pretentious, but where we have states and we have the national government, and there's a lot of coordination between them.
Is there also some disagreement?
Oh, please. Among civil libertarians, there's never unanimity, almost never unanimity. The whole reason that the ACLU's National Board of Directors, 83 people, gets together 8 days a year is to debate each other. And I don't want to overemphasize the disagreements. I think, on 99% of issues we would agree, but we come together to focus our attention precisely on the ones where we disagree. And there are issues where reasonable civil libertarians certainly could disagree, particularly when you are talking about issues where more than one civil liberty concern is involved. How do you strike the balance? I remember ferocious and vigorous debates a little bit more than a decade ago when sexual harassment was coming to the forefront in terms of people engaging in expression at work, including in academic workplaces, that conveyed sexist ideas, at least arguably. Is that something that should be treated as punishable sexual harassment because you are creating a hostile work environment for the female employees or professors or students? Or is that something that should be treated as protected free speech, which is especially important in an academic environment? And all of us would agree that you have to protect both values. How exactly you strike the right balance between them, obviously reasonable civil libertarians can and do disagree.
Did the ACLU have a position on that?
Oh, yes. We have a policy in our policy guide that does try to strike the balance.
What is that balance?
I can't remember the exact phraseology, but basically that there is a very strong presumption in favor of free speech unless the expression is directly targeted at a particular individual and it is intended to, and it has the effect of making it impossible or difficult for that person to function equally in the work environment. It's quite similar to the position we took with respect to campus hate speech codes. And this is a perfect example of where we defend freedom to advocate ideas that we vigorously dispute. I mean, we've been in the forefront of the civil rights movement, but we still defend the rights of people to make racist statements. They may not do it, though, in a targeted way that is aimed at a particular individual that makes that individual unable to function in a workplace or in a campus setting. But that's very different from saying you may not make a general racist statement or sexist statement.
But I'm an African American student in a class, and the professor doesn't direct the statement at me. It makes a general statement, but I'm sitting there, and I'm feeling the effects. How is that a balance?
Well, unfortunately, I guess it's not even unfortunate. If you are really going to defend free speech, that means that you are going to have to be willing to experience anger, offense, insult, hurt. That's the price we pay for living in a free society. I think a professor who does that probably deserves not to have tenure or deserves to be chided by the dean, because that is not an effective teaching device unless the professor is making a general point that has some pedagogical value. And there have been some cases actually involving City University, I think within the last 10 years, faculty members who were doing research and making controversial generalizations, in one case about Africans being intellectually superior, in another case the opposite conclusion, and the professor is free as a matter of academic freedom. Both of these cases were litigated and the courts agreed. The ACLU was there defending the academic freedom of the professor to express those controversial ideas, but not to actually discriminate against the students in terms of grading or so forth. But no student has a right not to feel offended in class. In fact, I think as professors, we should constantly challenge our students and feel free to make provocative statements.
Some people would say, you know, you're not talking about people of equal power.
Right.
I mean, a faculty member professor has power over the student. The student has no power over the professor.
I completely...
So these are unequal relationships.
But I completely agree with that, and that's why I think a responsible professor would be very, very careful not to say things that will make a student feel that they are going to be discriminated against. But I also think that we do owe it to them when they are in college to deal with ideas, not to trim our words when it comes to ideas that are intellectually defensible. And by the way, that is my assumption. There is no business of any professor saying anything in class for which there is not some plausible academic, factual, intellectual support.
We could get into an interesting discussion about what is fact.
Yeah, it's tough. You know, as a teacher, I am very, very careful about what I say, but I want to respect the students' feelings. I'm aware of the fact that they're less mature, less experienced, but I also feel I'm educating them to be professionals. I'm not going to trim back on ideas that are challenging and difficult and even upsetting.
Let's turn to a current issue, the Patriot Act, and the concern about safety and security versus individual rights. Where is the ACLU in all of that?
The ACLU, starting immediately after that dread date of September 11th, 2001, launched what we called our Safe and Free campaign. We believe that it is a false choice to say you can either be safe or free and not preserve both values. And what we have been demanding with respect to every government action, including the Patriot Act, is actually the same position that the Bipartisan Citizens Commission came out with this summer, which is a presumption in favor of individual rights. If the government says we have to cut back on a particular right to fight the war on terrorism effectively, the burden of proof is on the government to show, number one, that that measure is effective in fighting terrorism, and number two, that it's narrowly tailored, that there's no other measure that would be equally effective that would cut back less on individual rights. I think one of the interesting things, Francis, about all of the studies that have been done in the years since the terrorist attacks, since the Patriot Act was passed, including the Citizens Commission, none of them have indicated that the reason or a reason for the attacks was lack of government power to engage in surveillance, to engage in investigation, to engage in prosecution. Rather, the problems were that the government did not effectively analyze or act on the massive amounts of information it already had under its already very expansive surveillance power. So why did we rush to give what John Ashcroft himself called sweeping new powers? That was his word, sweeping new powers under the Patriot Act.
Well, you know, I've heard people, to my great surprise, who said to me, I give up my civil liberties for security. I can understand that. I certainly want to be alive. I have no death wish. But here's the answer that I give to those people. Yes, of course it makes sense to be willing to give up your freedom to gain security. But it does not make sense to give up your freedom if you are not gaining security in return. How do you know?
Well, we can know if we can get information from the government, well, we can know in two ways. Number one, we look backward and we say, what was it that led to that catastrophic failure of protecting security on September 11th? Was the failure due to the fact that we have too many civil liberties? I've not heard a single piece of evidence that supports that conclusion. I mean, in fact, the 9/11 Commission and Richard Clark and Colleen Rowley, other government experts and intelligence experts that have studied the situation have said, no, the pieces of the puzzle were already there. The problem was failure to communicate among bureaucracies and failure that related not to legal bars on communication, but rather cultural barriers between the FBI and the CIA, turf wars, personnel issues. The failure was due to the fact that we didn't have enough translators who spoke the relevant languages. The problem was an antiquated computer system in the FBI, so they couldn't even process all of the communications they were already intercepting. In some ways, to say what we need is more surveillance power is the worst of both worlds, because number one, it does away with the freedom of innocent people who are now subject to all kinds of surveillance under the Patriot Act, even without any basis for suspecting us of wrongdoing. But from a national security point of view, it's counterproductive because it's diverting attention and energy from the prosaic but essential steps that need to be taken in terms of computers and translators and actual cooperation among agencies.
So what is, with respect to the Patriot Act, which has allowed, at this point, a tremendous amount of intrusion into private lives. The FBI now has the power to look into the records of international students in this country.
And local students, by the way. All records of any of us can be turned over secretly to the government. I think it's really important for people to know that, because it's always the power is always misdescribed by government advocates. I have debated them all over the country. They read from the same script. People don't have to take my word for it. They should go to the ACLU website, where we provide a link to the actual language in the law. The infamous Section 215, which many people know of because of the application in libraries, but it's so much broader than that. It literally allows the government to ask anybody for any tangible thing, including any kind of record, merely by asserting that the record is sought for, the tangible thing is sought for in connection with a counterterrorism or counterintelligence investigation. They don't have to specify that you, whose records they're going to get, are the subject of the investigation, just that it is sought for an investigation. At that point, the entity from whom the materials are sought must turn them over and must not tell you that it has turned over your records. There's a gag order there, and that literally applies to every record, every tangible thing, every person in this entire country.
So are you in court on this?
We are. That is Section 215 of the Patriot Act, which we brought a constitutional challenge against last summer. It's still pending before court. And we've argued that it violates not only our Fourth Amendment right to be free of unreasonable searches and seizures, but also our Fifth Amendment due process right, because how can you defend your precious privacy if you don't even know that the government has invaded it because of this gag order that's in the provision? You, for example, could be requested to turn over all your student records, and you would be criminally barred. I mean, barred on crime of pain of criminal penalty from telling any of the students. So their due process rights are violated, and also First Amendment rights are violated. If you know that your library records, your web surfing records, your book borrowing records, book buying records can be turned over, then that may well have a chilling effect on what you're going to read, what you're going to borrow, what web surfing you're going to engage in. So it's a chilling effect on First Amendment freedoms as well. And we're eagerly awaiting the judge's ruling in that
When will
lawsuit.
that happen?
They are under no time constraints at all.
Is it your sense that there's any widespread popular understanding of what you've just said?
I think there is, actually. And one very positive indication of that, Frances, is an absolutely unprecedented grassroots community resolution movement that has now affected 41 states in this country, almost 360 separate communities that have adopted pro-civil liberties resolutions calling for the government to cut back on the unjustified overreaching provisions in the Patriot Act, and including Section 215. And the communities that are involved are Republican and Democrat, liberal and conservative, small towns, big cities, you name it. They represent 20% of all people in this country, and Congress is getting that message.
Is this issue of concern in either of the platforms of the Democratic or Republican Party?
I must say I'm not familiar with the platforms. I do know that the president is a very strong advocate of the Patriot Act and opposing even the sunsetting of the few provisions that are due to expire at the end of next year. John Kerry, along with every other member of the Senate, with one sole exception, did vote for the Patriot Act, but has had second thoughts and is one of many sponsors of bipartisan reform legislation that would cut back on the unjustified overreaching provisions in that act.
Well, as with our other topics, we could continue to talk, but I'm sorry we're out of time. Our thanks to Nadine Strossen, President of the American Civil Liberties Union, for joining us. For the City University Graduate Center and Women to Women, I'm Frances Deegan Horowitz.